Okay, so now we're going to cover appeals from rulings of the trial courts. This is it's 25 substantive slides. I'm going to go through it pretty quickly because it's covered in the material. Let's get right to it. The appellate process, right? That's where there's been a ruling at the trial court level. Remember the structure of the court system. It's like a layer cake. There's a broad base of trial courts at the both state and federal level. Trial courts are the broad base. Then there are the first level appellate courts above the trial court. Then there are the second level appellate courts, like the Supreme Courts, the Massachusetts Supreme Judicial Commission, that are above the first level trial courts. Each level refines the issue it faces. Why are these important? Because appeals shape both the actions of the lower courts beneath it, but they also shape national policy. What's the purpose of an appellate court? Well, one is to correct errors in the court below. Usually these are errors of law, not of fact. What advantages do appellate courts have? Well, they have time. Cases on appeal, you have time to really take your time to read all the briefing, to focus on a single issue. There's more judges. By correcting the errors of law, the first appellate courts help to shape the law. And also by increasing the clarity and consistency of the law, they give the actors, they give attorneys and parties and lower court judges certainty about what will happen. It's a way to organize society. There's a concept called the one appeal concept, which says that generally speaking, parties get one appeal as a right. That means that if you lose at the trial court, you usually get the right to appeal your loss one time. Now that doesn't include, as we talked about before, if you are found not guilty of a crime, you can't appeal an acquittal. So parties get one right to appeal. Now we talked about how the Supreme Court has discretionary jurisdiction and does not have to hear a case. So the Supreme Court and the SJC and things like that, they don't have to hear cases. You get one appeal, but not two. At the appellate level, questions of law predominate. The jury is called the finder of fact, and the appellate courts almost never overturn findings of fact from the trial court. So usually, it's got to be an issue of law, and it has to be raised and ruled on at the trial court level. That is to say that if a party feels there's an error being made, they have to say so at the trial court level in order to preserve the issue for appeal. Now what happens if in the middle of the trial, the judge makes a ruling that the parties think is so egregious, a ruling about evidence or a ruling about, jury instruction or something, and the parties feel like it's so egregious they want to appeal right away? Well, you can do that. It's not that common, but it's called an interlocutory appeal, and it's when you raise an appeal in the middle of a trial before the trial is over. Appellate courts don't really like that very much because it's kind of an emergency, and it's not always the best move as a trial court attorney because you're basically questioning the judge in the middle of the trial. The actors in the appellate procedure, you have judges. Usually it's more than one on appellate courts. Remember, there can be a panel of 3 or 5 or 9. We talked about law clerks and how they do the research, and sometimes they draft the opinions. You can have appellate specialists. You can have the parties, obviously. Sometimes criminal appellants who are in jail have plenty of time to represent themselves on appeal. Sometimes parties don't really get involved in the appeal at all. They're not going to be appearing before the appellate court usually. Usually they just send their lawyers. Some cases fall under mandatory jurisdiction. The appellate court has to hear the case. In these cases, the aggrieved party, meaning the one who is appealing, is called the appellant, and the appeals process begins when the appellant files an appeal and a brief in support. The appellee then files a response, and the appellant files a reply, and that's how you make a record for your appeal. Other cases fall under what's called discretionary jurisdiction. Now, the appellate court can decide. That's when, like the Supreme Court, can decide whether to hear an appeal or not. In that case, the aggrieved party is called the petitioner, because the first thing that they do is they petition the appellate court to hear the case. That's why at the Supreme Court level, it'll say so-and-so petitioner and so-and-so respondent. Remember that only 4 out of the 9 Supreme Court justices have to vote in favor to hear an appeal in order to grant a petition for review. Under either of these kinds of jurisdiction, once the appellate court takes the appeal, then there's a briefing schedule. And the briefing schedule is where the parties file their briefs and they argue in the briefs about things. And then there can be oral argument. There may also be something called motion practice. Motion practice is where parties file motions, which is in which they're asking the court to do something. You move the court for some sort of relief. The other side may oppose the motion. Then there might be a hearing. Oral argument is when you've made a motion, the court has scheduled a hearing, and the parties go in and they make their oral arguments to the judge directly. Usually, let me pause for a second. The appellate courts generate a written opinion. Oftentimes the trial court doesn't generate a written opinion. There's just a jury verdict. But at the appellate level, there's a written opinion. And then there can be dissenting or concurring opinions that go with it. After the appellate court sets or issues a written opinion, they can decide whether to send the case back to the trial court or whether they want to resolve it at the appellate level. Oftentimes, if the appellate court makes a ruling on something, they'll remand the case back to the trial court with instructions on how the trial court should proceed. Sometimes there are alternative systems designed to decrease the oral arguments or designed to streamline the process by assigning one appellate attorney or staff attorneys to decide these appeals. Sometimes there are even systems designed to alter the form. It can be a written or a verbal opinion, published or not published, long or short. What are some of the issues? Well, there are a lot of issues, right? I mean, they're discussed in the book. But, a system where there's no oral argument means that attorneys don't get to respond in real time to issues that the appellate courts might think are important. A case where there's no oral argument might give preference to lawyers who are better writers, to lawyers who are more familiar with the ways in which appellate courts do things. Cases where the opinions aren't issued or published mean that you can't rely on those rulings as precedent, which may be important if you're trying to understand how to moderate your behavior based upon prior rulings. If the opinion of the Supreme Court or of the appellate court is not published, then you can't rely on it, and therefore you don't quite know how to proceed. Now let's say that you've decided to appeal the case. You've got a lot of things to think about. You're already in the system. You're already paying legal fees. You've already gotten an adverse decision. There are a lot of things to think about before you appeal. Maybe you decide, I'm already doing it. I'm already sort of shelling out for this. But and so therefore, yes, I want to appeal. Definitely want to appeal. But there are three factors that weigh heavily on that decision. One of them is, what have you lost? How much money? How much of your freedom have you? Are you going to jail for 10 years? Have you lost $1 million? What more do you have to lose? If you don't have anything more to lose, then you might want to appeal. If you have a lot more to lose, then you might say, well, you know what? I'm going to cut my losses now and not appeal. The next factor is the chances of success. What are you appealing? Are you appealing a small ruling, a ruling that's really egregiously wrong? Has the appellate court already ruled in a similar case that looks like you're going to do okay? Do you think that maybe because there's no jury at the appellate level, you'll be more appealing to the courts? Is there a reason why appealing just kind of lets you delay to the point where it works in your favor? Maybe you have a lot of money. Maybe you're a corporate client with a ton of money, and you think, you know what? I'm just going to keep delaying this ruling by appealing as long as I can and slowing it down so eventually the other side says, forget it. And then the third factor is cost. The appellate process is expensive. Can you afford to appeal? If you were to win an appeal, what would you get? Would you just go back to the trial court? Can you afford that? Oftentimes the government, the state, they're always appealing because they are a repeat player. They can afford to lose individual cases if they want to press a rule of law. The government lawyers, the state appellate lawyers, can develop expertise, and they get very, very good at being heard on appeal. Private litigants, people who are just hiring their own attorneys, it's very, very rare that they get their appeals heard and or ruled in their favor. Political litigation, this is what we're going to get into in Module 3. It's a case brought in pursuit of some larger political goal. And political actors, whether it's an interest group or a trade group, are looking, they're always on the lookout for good cases to use to press a larger goal. And we'll see this in Module 3 when we get to gun rights cases and same-sex marriage cases and other cases. You are looking for the right case to bring to appeal because you want to further a goal, and you save your money and you wait until a good case comes along. Classic political litigation. That's a case brought with a goal of winning a favorable ruling on some issue. But you can also bring tactical litigation, which is a case brought to gain some sort of advantage in a conflict over politics or policy. If you bring attention to it, even if you think you're going to lose, you can change public perception. Our book has a section on a Happy Meal litigation, which was brought to highlight the marketing and made McDonald's change its marketing, change it so it couldn't market Happy Meals to kids. There are a lot of interest groups involved in appellate litigation. The NRA is very involved, the ACLU, the NAACP, Mothers Against Drunk Driving, the Center for Constitutional Rights is very involved, and these groups are on the lookout for good cases to use to bring. Oops, I'm going to go back. Sorry, I'm going to go back one or two. Yep. Now these groups can bring their appeals through direct sponsorship, where they look for plaintiffs and they pick up those cases and they pay for them. They can find a case that's already in the court system and begin to pay for it, or they can file these briefs that are called amicus curiae. Amicus curiae are briefs that are called friend of the court briefs. Most of the time, these interest groups will just file a brief in support of an issue without actually taking up the role of a party or paying for a party. We talked about tactical cases where you sue to delay or sue to influence public policy. In California, there's a lawsuit called the Anti-Slap Statute. A SLAP is a strategic litigation against public policy or public participation. It's where a deep pockets party might sue a small group to punish them for getting involved in an issue, whether a party wants to develop some protected wetlands and they are sued by a local group who says you can't do that, and or they preemptively sue a local group and say, we're going to sue you for all this stuff, thinking that the cost of the litigation will get in the way of the people's ability to stop them from developing the wetlands. California has a law called the Anti-Slap Statute that lets those defendants quickly make a motion to win the case on the merits, but also get their attorney's fees. There's been a lot more appeals in the last 10, 15, 20 years, 30 years, 40 years. As I said before, the Supreme Court hears 1% of the 8,000 appeals. 8,000 appeals it is asked to hear each year. The Supreme Court develops what's called a discuss list, which is where it's a list of the petitions it thinks about hearing. The law clerks evaluate those cases. Think about the power that a law clerk has to decide whether or not to put a case on the discuss list. And how do they decide what to take? Well, they ask, how significant is the legal issue? Are there rulings from lower courts that are in conflict? Is the law in really bad shape? How wrong was the lower court? Is something going on in the lower court that they need to really correct? Or how strongly do these justices want to see their own policy preferences affected? That is to say, if you're a justice and for years you've been hoping for the right case that would let you promote a policy preference of your own, is this the right case for you? We'll pause here and we'll finish up with this PowerPoint in one more presentation.